Thank you for attending this public meeting of the United States Sentencing Commission. This is the Commission's final meeting in 2016. The Commission will end the year with a number of transitions and vacancies as it marks the final meeting of my 6-year term as Chair of the Commission, which expires when the Congress adjourns. So sadly, this will be my last opportunity to address you as Chair of the Commission. Typically, my remarks to you focus on our recent activities and our plans for the immediate future. At the end of the meeting, I will also look back to the important, exciting period in the Commission's history. But before I do that, I would like to introduce the other members of the Commission. I'll start with Judge Charles R. Breyer. He is a senior district judge for the Northern District of California and has served as the United States District Judge since 1998. He joined the Commission in 2013 and serves as a vice chair. Now, I usually just have this technical I give credentials, but I'd also like to add this. Judge Breyer has been a friend for a long time. He is one of the best known and beloved judges in the federal judiciary. His insights from many years as a trial judge have been invaluable to the Commission. Hopefully, he will have the opportunity to serve a second term, as his first term is also ending at the end of the congressional session. Next, we have Dabney Friedrich, who has served on the Commission really more than a decade, since 2006. Immediately prior to her appointment to the Commission, Commissioner Friedrich served as Associate Counsel at the White House. She previously served as counsel to Chairman Orrin Hatch of the United States Senate Judiciary Committee and as an Assistant U.S. Attorney for the Southern District of California and for the Eastern District of Virginia. This also marks the final meeting for Commissioner Friedrich. I first met her when we were bookends together. We came through the confirmation process and we were sworn in together. For the full last decade, she has been an active and hard-working member of the Commission, contributing greatly to our decisions. She's actually a math whiz. She understands the statistical analysis and the data analysis and has been so helpful to understanding the policies of the Commission. Our staff, in particular, would love to thank her. They all have told me this, for her very supportive efforts. She has also been very impactful in prison reform efforts to better educate prisoners in the Bureau of Prisons, particularly those with learning disabilities. She's been a valued member of the Commission, often offering that one idea, like you're fighting to try and figure out how we can reach compromise, how we gonna get this important amendment through. And she has often been the one who's given that one extra idea or that one insight that's brought closure to the process. I can't imagine. She's now in California and not seeing you a lot. Next is Judge William H. Pryor, who also joined the Commission in 2013. Judge Pryor is a United States Circuit Court for the 11th Circuit Court of Appeals, appointed in 2004. Before his appointment to the federal bench, Judge Pryor served as Attorney General for the state of Alabama, and he is also responsible for the creation of the Alabama Sentencing Commission. You've heard about thinking fast and thinking slow. Judge Pryor thinks deeply. Judge Pryor is a true scholar who thinks about the big picture of sentencing policy. And next is Rachel Barco. I refused to tell them what I was going to say in advance, who also joined in 2013. Commissioner Barco is the Siegel Family Professor of Regulatory Law and Policy at the New York University School of Law, where she focuses her teaching and research on criminal and administrative law. She brings extensive academic knowledge to the Commission. She knows everyone in the Academy who's thinking about these issues. She is not only knowledgeable about sentencing policy, but also in other important substantive areas that affect our work, like mens rea law. She serves as faculty director of the Center on the Administration of Criminal Law at the law school. I'd also like to recognize Michelle Morales, who serves as the designated ex officio member of the Commission. She has the important and, I think, sometimes daunting task of representing all the different viewpoints within the Department of Justice. Commissioner Morales is the acting director of the Office of Policy and Legislation in the Criminal Division of the Department. She first joined that office in 2002 and has served as its deputy director since 2009. Commissioner Morales served previously as an AUSA in the District of Puerto Rico. There's some special guests who I think are here. Carter Burwell is here as counsel to Senator Cornyn. Welcome. Um, um, Nikichi Taifa, I think I said that correctly, from the Open Society and Justice Roundtable. Sakira Cook from the Leadership Conference. Jesslyn McCurdy from the ACLU. Mary Price from FAM. And Denise Barrett and Laura Mate, Sentencing Research Council. Now, I'm always a little embarrassed to do this because somebody may have come in afterwards and I missed you. And so if that is the case, I'm sorry. But we really welcome everyone who's here right now. I want to do a few business items to begin with. As some of you know, we have expanded our national training opportunities for judges and practitioners in recent years. In June, about 100 judges attended our first ever training for judges in Chicago, and the feedback was so positive that the Commission is holding another training session for judges in 2017. On September 7th to 9th, the Commission held its annual national training program in Minneapolis, and we had 850 attendees. I'd like to recognize and acknowledge the excellent work of the Commission's staff who organized the event and conducted the individual sessions. We've received some feedback from the seminar participants that the national training program has grown too large. To respond to this feedback, but to also accommodate the continued demand for our training programs, we have decided to hold a national training program series next year. So the first in the series that is open to the public will be May 31st to June 2nd in Baltimore, and the second will be September 6th to 8th in Denver. We also will hold a judges-only training program in San Diego on June 22nd to 23rd. Registration is not yet open for these programs, but you can check our website for more details in the weeks ahead. So, as you know, an important part of our process are the advisory groups. In October, the chair and vice chair of the Commission's Practitioner Advisory Group, or PAG as we call it, completed their terms of office. I would like to take a moment to acknowledge their service and thank them on behalf of the Commission. Eric Tershwell served as chair of the PAG from October 2015 to October 2016, following his previous service as vice chair. Nancy Clarence served as vice chair for 1 year and was a member of PAG since 2013. Nancy practices law in San Francisco with Clarence, Dyer, and Cohen. Existing members of the PAG have taken over leadership roles, and I'd like to acknowledge them and thank them for their service as well. The new chair, who's been on the advisory group since 2012, is Ronald Levine, who practices law in Philadelphia. Ron is a principal at Post & Shell in the firm's business law and litigation department and chair of the firm's internal investigation and white-collar defense group. The new vice chair, Knute Johnson, who practices criminal law in San Diego and is the Criminal Justice Act representative from the Southern District of California. He's been a member of the PAG since 2015. We are grateful to them and all the members of the Commission's advisory groups for their continued service to the Commission. And as I mentioned, we have a new advisory group. Chief Judge Ralph Erickson from the District of North Dakota will serve as the TIAG's chair. The other members have been announced on our website, and we thank them for their time and service. So now we get down to calling the meeting to order, and I'm going to turn to our excellent General Counsel, Kathleen Grilly.
Judge, the first item of business for your vote is a vote on the meeting minutes from the August 18th, 2016 meeting. A motion to adopt the minutes would be in order at this time.
Do I hear a motion? A second?
Second.
Any discussion? All in favor?
Aye.
Any opposed?
Motion carries. The next item of business for you are a series of proposed amendments for publication, the first of which is a proposed amendment on first offenders and alternatives to incarceration. This proposed amendment contains two parts, parts A and B, either of which may be promulgated since they are not mutually exclusive. Part A sets forth a new Chapter 4 guideline at 4C 1.1 called First Offenders that would provide lower guideline ranges for first offenders generally and increase the availability of alternatives to incarceration for such offenders at the lower levels of the sentencing table. Part B of the proposed amendment would expand Zones B of the sentencing table by consolidating Zones B and C. Part B also amends the commentary to 5F 1.2 for home detention to remove language requiring electronic monitoring. Each part includes issues for comment. A motion to publish the proposed amendment, as I just stated, with an original comment period closing on February 20th, 2017, and a reply comment period closing on March 10th, 2017, with technical and conforming amendment authority to staff would be in order at this time.
Thank you.
moved. Second.
Any discussion? All in favor?
Aye.
Any opposed? Now, just a few comments here. The Commission is considering this proposed amendment to reduce the penalties for first-time offenders and to increase the availability of alternatives to incarceration. Last year, the Commission studied alternatives to incarceration and found that alternative sentences were imposed in only 13% of federal cases. Increasing the use of alternatives may further decrease the overcapacity issues within the federal prison system. We've also been informed by our ongoing recidivism research that shows that true first offenders have a significant lower recidivism rate than offenders with one criminal history point. 30.2% for offenders with zero criminal history points recidivate, as opposed to 46.8% for those with 1 point. So the Commission would like to consider greater use of alternatives, especially for first-time offenders. Today, we are publishing a proposed amendment that could increase the use of alternatives by combining zones B and C, perhaps adding a downward adjustment for certain first-time offenders, and adding commentary encouraging the use of alternatives to certain categories of offenders. Now we can have a vote? We just did? Right, okay. We've adopted it. Let the record reflect it was unanimous. So is there another motion?
Yes, Judge. The next amendment before you for consideration is an amendment titled Tribal Issues, which arises from the recommendations contained in the ad hoc Tribal Issues Advisory Group report that was submitted to you this summer. The proposed amendment contains two parts, again, neither of which are mutually exclusive. The first part relates to criminal history and the use of tribal court convictions. Currently, those are not counted for purposes of calculating criminal history points, but may be considered for a departure based on inadequacy of criminal history. Part A of the proposed amendment would amend the commentary to 4A1.3 to set forth a non-exhaustive list of factors for the court to consider in determining whether and to what extent an upward departure based upon a tribal conviction is appropriate. Part B of the proposed amendment responds to concerns that the term court protection order has not been defined in the guidelines and should be clarified. The proposed amendment would amend the commentary to 1B1.1 to provide such a definition. Each part includes issues for comment. A motion to publish the proposed amendment with a public comment period, an original comment period closing on February 20th, 2017, and a reply comment period closing on March 10th, 2017, with technical and conforming amendment authority to staff would be in order at this time.
So moved.
Second. Any discussion? I'll make the following comment. Based on the dedicated work of Commission staff, federal judges, and stakeholder groups, the Commission successfully established a Tribal Advisory Issues Group, which published its report on the unique federal sentencing issues relating to American Indians in June of this year. As a result of that report and the subsequent hearing, the Commission has established a permanent Tribal Issues Advisory Group in August of this year. I mentioned that just earlier. In considering and implementing this group's important work, the Commission examined the impact of the federal sentencing guidelines on tribal issues. The Commission is putting forth a proposed amendment that responds to the TIAG's recommendations regarding tribal court convictions and set forth 5 factors for a sentencing judge to consider when determining whether and to what extent an upward departure may be appropriate based on a defendant's history of tribal court convictions. A vote is now in order. How many in favor?
Aye.
Opposed? It carries. Thank you.
The next amendment before you for your consideration is titled Youthful Offenders. Currently, under the criminal history rules in the Guidelines Manual, sentences for offenses committed prior to the age of 18 are considered in the calculation of defendant's criminal history score. The guidelines distinguish between an adult sentence in which the defendant committed the offense before the age of 18 but was convicted as an adult, and a juvenile sentence resulting from a juvenile adjudication. The guidelines provide different time periods within which each type of sentence is included in the calculation of criminal history score. The proposed amendment amends 4A1.2D to exclude juvenile sentences from being considered in the calculation of the defendant's criminal history score. The proposed amendment also amends the commentary to 4A 1.3 to provide an example of an instance in which a downward departure from the defendant's criminal history may be warranted for an adult conviction committed prior to the defendant's 18th birthday. The proposed amendment also includes issues for comment. A motion to publish the proposed amendment with an original comment period closing February 20th and a reply comment period closing March 10th, 2017, and technical and conforming amendment authority to staff would be in order at this time.
Is there a motion?
So moved.
Is there a second? Any discussion? The Commission is considering a proposed amendment that targets youthful offenders under the guidelines. This proposal will exclude juvenile sentences from being considered in the defendant's criminal history score. It also provides a list of certain offenses that should never be counted for purposes of criminal history score, including juvenile status offenses and truancy. In light of the growing adolescent brain development research and recent court decisions, we welcome public comment on this issue. It's time for the vote on this. All in favor?
Aye.
Any opposed? It carries, and let the record reflect that at least 3 commissioners voted in favor of this motion to publish. The General Counsel will now advise us on a possible vote concerning an amendment on the Bipartisan Budget Act.
Yes, Judge. The Bipartisan Budget Act amendment, which is before you, responds to the Bipartisan Budget Act of 2015, which added new subdivisions to 42 U.S.C. sections 408, 1011, 1383A, prohibiting conspiracy to commit fraud with the same statutory maximum penalties applicable to the substantive offenses that exist in those statutes. The statutes that were amended are currently referenced in Appendix A to 2B 1.1, but the proposed amendment would amend Appendix A so they are also referenced to the conspiracy guideline 2X11. The Bipartisan Budget Act also amended those statutes to add increased penalties for certain persons who are specifically defined in the statute who commit fraud offenses under relevant Social Security programs. The new increased penalties, 10 years, apply to all of the fraudulent conduct in subsection A of the 3 statutes. The proposed amendment would amend 2B11 to address cases in which the defendant was convicted of any one of those statutes and to whom the increased statutory maximum term applies. It provides a bracketed enhancement of either 2 or 4 levels and a minimum offense level of 12 or 14 for such cases. It also adds commentary concerning the applicability of the abusive position of trust adjustment in 3B 1.3, bracketing 2 possibilities for that as well. Issues for comment are also provided. Motion to publish the proposed amendment with an original comment period closing February 20th and a reply comment period closing March 10th, 2017 would be in order at this time with technical and conforming amendment authority to staff.
So moved.
Is there a second?
Second.
Any discussion? In response to the Bipartisan Budget Act of 2015, the Commission is also considering a proposed amendment that reflects Congress's changes to the Social Security Act by increasing penalties for Social Security fraud. I would like to acknowledge the important years of work as well as the continued oversight led by the House Judiciary Committee, the Senate Committee on Finance, and the House Ways and Means Committee to ensure aggressive implementation of these new penalties relating to Social Security fraud. Is there a vote? All in favor?
Aye.
Any opposed? Motion carries to publish. The General Counsel will now advise on the first possible vote concerning a proposed amendment on acceptance.
Judge, if I may actually go back to an amendment
All right, that's
on
fine.
criminal history issues.
All right.
This proposed amendment is a result of the Commission's work in examining Chapter 4. Chapter 4 of the guidelines currently count revocation of probation, parole, and supervised release, special parole, or mandatory release for purposes of calculating criminal history points. Adding the sentence of imprisonment imposed upon revocation to original sentences of imprisonment and treating the total as if it was one sentence for purposes of calculating criminal history points. Part A of the proposed amendment would amend 4A 1.2K to provide that those revocations are not to be counted for purposes of criminal history score. It would also state that such revocations may be considered as ground for departure under 4A 1.3, which is departures based on an inadequacy of criminal history category. Part A also includes issues for comment. Part B of the proposed amendment would amend the commentary to 4A1.3 to provide that a downward departure from the defendant's criminal history may be warranted in cases in which the period of imprisonment actually served by the defendant was substantially less than the sentence imposed. A motion to publish the proposed amendment on criminal history issues with an original comment period closing on February 10th and a reply comment period closing on March 10th, 2017, and technical and conforming amendment authority to staff would be in order at this time.
So moved.
Is there a second? Any discussion? All in favor?
Aye.
Any opposed? Carries. Ms. Gurley?
Yes, Judge, the next amendment is the acceptance of responsibility amendment. This amendment, proposed amendment, responds to concerns that the commentary to 3E1.1 encourages courts to deny a reduction in sentence when a defendant pleads guilty, accepts responsibility for the offense of conviction, but unsuccessfully challenges the pre-sentence report assessment of relevant conduct. The proposed amendment amends the commentary to 3E1.1 to revise how the defendant's challenge of relevant conduct should be considered in determining whether the defendant has accepted responsibility for purposes of the guidelines. An issue for comment is also provided. A motion to publish the proposed amendment, as I just stated it, with a public comment period closing February 10th, an original comment period, the February 20th, reply comment period closing March 10th, 2017, and technical and conforming amendment authority to staff would be in order at this time.
Is there a motion? Second?
Second.
Any discussion? All in favor?
Aye.
Any opposed? Thank you. It carries.
The next amendment for your consideration is the miscellaneous amendment, which responds to recently enacted legislation and miscellaneous guideline issues. It contains 4 parts. Part A responds to the Transnational Drug Trafficking Act of 2015 by amending 2B 5.3. Part B responds to the International Megan's Law to prevent child exploitation and other sexual crimes through advance notification of Traveling Sex Offenders Act by amending 2A 3.5, 2A 3.6, and Appendix A. Issues for comment are also included in this part. Part C responds to the Frank R. Lautenberg Chemical Safety for the 21st Century Act by amending Appendix A, and Part D amends 2G 1.3 to clarify how the use of a computer enhancement at subsection B3 of that guideline interacts with its correlating commentary. A motion to publish the proposed amendment with an original comment period closing February 20th and a reply comment period closing March 10th, 2017, and technical and conforming amendment to staff is in order at this time.
Do I hear a motion? Second? Any discussion? All in favor?
Aye.
Any opposed? It carries. Thank you.
The next proposed amendment for your consideration is the marijuana equivalency technical amendment, which makes technical changes to 2D 1.1 to replace the term marijuana equivalency with the term converted drug weight. It also changes the title of the drug equivalency tables to drug conversion tables. A motion to publish the proposed amendment with an original comment period closing February 20th and a reply comment period closing March 10th, 2017, with technical and conforming amendment authority to staff would be in order at this time.
Do I hear a motion?
So moved. Second.
Any discussion? All in favor?
Aye.
Any opposed? All right.
The next amendment is a technical amendment. This proposed amendment makes various technical changes to the guideline manual. It also has several parts. Part A makes clarifying changes to Chapter 1, Part A, and to Application Note 2A of 2B 1.1. Part B makes technical changes in 2Q 1.3, 2R 1.1, 4A 1.2, and 4B 1.4. Part C of the proposed amendment makes clerical changes to the commentary to 1B 113, subsections D6 and E2 of 2D 111, the commentary to 2M 2.1, 2Q 1.1, 2Q 1.2, 2Q 1.3, subsection A4 to 5D 1.3, and the lines referencing 18 United States Code sections 371 and sections 1591 in Appendix A. A motion to publish the proposed amendment with a comment period closing February 20th and a reply comment period closing March 10th, 2017, with technical and conforming amendment authority to staff would be in order at this time.
Thank you. Is there a motion?
So moved.
Second? Any discussion? All in favor?
Aye.
Any opposed? Carries. Ms. Gurley.
Yes, Judge. The final vote to publish is on an issue for comment titled Drugs. In August 2016, the Commission indicated that one of its priorities this year would be the study of offenses involving MDMA ecstasy, synthetic cannabinoids such as JWH-018 and AM2201, and synthetic cathinones such as methadone, MDPV, and mephedrone. The Commission intends that this study will be conducted over a 2-year period. The issue for comment seeks comment on the following factors as it relates to each of the drugs that I just mentioned: the chemical structure, the pharmacological effects, the legislative and scheduling history, the potential for addiction and abuse, the pattern of abuse and harms associated with abuse, and the patterns of trafficking and harms associated with trafficking. The issue for comment also seeks broader comment on offenses involving the synthetic cathinones and synthetic cannabinoids and the offenders involved in such offenses. A motion to publish the issue for comment with a public comment period closing on March 10th, 2017, and technical and conforming amendment authority to staff would be in order at this time.
Thank you. Is there a motion to publish the comment, the issue for comment? Is there a second? Second. Any discussion? Let me just say that the Commission is publishing an issue for comment that initiates a 2-year study on synthetic drugs, including synthetic cannabinoids, cathinones, and MDMA. Now that I'm leaving, I finally can pronounce all these drugs. The study will consider, among other things, whether to add new substances to drug equivalency tables. In light of the increasing trend of synthetic drug cases in the federal docket, the Commission believes that it is appropriate to further examine the issue. The Commission welcomes any public comment on the impact of synthetic drugs as we conduct this study. We want to make sure that the penalties are appropriate and the guidelines are well informed. Is there a vote? All in favor?
Aye.
Any opposed? It carries. Thank you. So now I move on.
May I say a comment?
Yes, of course.
Thank you. We are indeed very grateful at the department for the Commission agreeing to do that study on synthetic drugs, which we believe is a really important issue. But I did want to note that we do have some concerns about some of the proposed amendments. We believe that some of the amendments as written could be overbroad and potentially benefit offenders that, frankly, in our opinion, do not merit such benefit. That said, we will express those concerns more fully and recommend ways to address them in the public comment. And as always, we will work closely with the Commission to find common ground so that we can find language that we can indeed support. So thanks.
Thank you. So I'd like to make a few concluding remarks about the transition. During this period of transition, I'd like to acknowledge that next year will mark the 30th anniversary of the Commission's first publication of the sentencing guidelines. Over the last 6 years, the proposed amendments to the guidelines have been developed and adopted in the same tradition of bipartisanship that has shaped the Commission during the last 3 decades. Over the last 6 years, the Commission's current membership has continued this remarkable tradition with an evidence-based and collegial approach to decision-making. Our efforts have resulted in significant policy decisions that we believe have contributed to a decrease in the federal prison population, which peaked in 2013 at 219,298 and now has declined to its current level of 193,303. That's a reduction of more than 28,995 offenders, or 13.2% over 3 years. It has been a pleasure to serve as chair of the Commission. I've learned so much from each and every commissioner I have had the honor to serve with. I started with my friend and former chair, Ricardo Hinojosa, with Ketanji Brown Jackson, now a judge, Judge Beryl Howell, and Commissioner William Carr, and ex officio Jonathan Wroblewski. I've become a big fan of our standing advisory groups, the practitioners advisory group, the probation officers advisory group, and the victims advisory group. I would also like to thank the Federal Defenders Guidelines Committee, Commission Liaison Subcommittee, and the Sentencing Resource Council for their assistance. I am enthusiastic about the future contribution of our Tribal Issues Advisory Group. These groups regularly meet with the Commission and help us in the formation of sentencing policy. I also would be remiss if I did not acknowledge the significant impact of the public comment in relation to our amendments to the guidelines, sent from a broad range of interested Americans and stakeholders during my tenure as chair. Your formal contact, your continued interest by coming, has helped us shape over 50 amendments that were promulgated during my tenure. And it's always a little dangerous doing this, just as I mentioned some folks who are here. I may be missing people, but some of the organizations that have really submitted the most public comment over the years, and I'd like to thank, are the American Bar Association, American Civil Liberties Union, the Drug Policy Alliance, Families Against Mandatory Minimums, which FAM, and I'd also like to thank Mary Price, who I don't think has missed a meeting since I've been here, the National Association of Assistant United States Attorneys, the National Association of Criminal Defense Lawyers, and the Sentencing Project. I'm sure there are more here, and I apologize in advance, but I've just in particular, we get these giant white binders with all of your comments, and I sit on my couch and I read everything, as do all the commissioners, and we talk about it when we come into our meeting, so thank you. It's also been a joy to work with the Commission staff of esteemed attorneys, social scientists, and other professionals with expertise in criminal justice and federal sentencing policy, along with the many other hardworking individuals who each contribute with their best efforts in their respective roles. When I was a judge up in Massachusetts, I had no idea the level of expertise and knowledge and commitment that went into each one of the guidelines, and that's because of our outstanding staff. I wanted to give a particular shout out to Staff Director Ken Cohen and our Staff Director before him, Judy Schoen. My first year here, those of you who've been following this, was a tough one. As I learned the ropes, and I have had the best of teachers, friends, and mentors. Our staff has provided all the commissioners with invaluable support and expertise, and together with all of you, the listening public, and the people who send us comments, hopefully we have been active in trying to make the guidelines and federal sentencing fairer and more proportionate while maintaining an ongoing commitment to public safety. When I first became chair 6 years ago, the BOP inmate population was 37% over capacity. I remember the head of the BOP sitting here and telling us that statistic. Now it is about half that. In 2011, my first year on the commission implemented new lower crack cocaine penalties from the 2010 Fair Sentencing Act and voted to apply these changes retroactively to benefit currently incarcerated crack cocaine offenders. In arriving at these decisions, the Commission found that the crack cocaine penalties were not proportionate to the harms on society, and that the impact of the unduly severe penalties were borne mostly by minorities. That decision resulted in 7,748 offenders receiving an average reduction in their sentences of 19.9% from 153 months to 123 months. Then, in 2014, the Commission voted to reduce the drug quantity table for all drug trafficking offenses, not just crack cocaine, by 2 levels, which reduced drug penalties going forward by about 17%. The Commission then voted to make those reductions retroactive, and to date, 28,544 drug offenders have received an average sentence reduction of 17%, or about 25 months, from 143 months to 118 months. It's important for the public to know, before sentencing reductions were granted, as a result of the 2011 or 2014 amendments, each individual case was reviewed by a federal judge to ensure that the offender did not pose a public safety risk. Simply put, none of these reductions are automatic. The Commission also had several other important amendments that became effective this year. In response to the Supreme Court's decision in Johnson versus United States, the Commission eliminated the analogous residual clause from the sentencing guidelines definition of crime of violence. The amendment will help relieve some of the strain on the courts and the broader uncertainty that has followed Johnson. In addition, this year the Commission published a report to Congress analyzing career offenders in the federal system and the statutory definition of crime of violence. In our report, the Commission recommended that Congress establish one definition of crime of violence for all criminal law purposes, and we encourage Congress to adopt the Commission's definition of crime of violence as that single uniform definition. We also strengthened and broadened the criteria for compassionate release with several meaningful changes. Congress charged the Commission with issuing policy statements describing what should be considered extraordinary and compelling reasons for sentencing reduction. Through the Commission's newly expanded criteria, federal inmates may be eligible for compassionate release based on 4 categories relating to medical conditions, age, family circumstances, or other extraordinary and compelling reasons. The Commission's action encourages the BOP to use its current authority if an eligible offender meets any of these circumstances. We also addressed the guidelines for illegal reentry offenses. The 2016 amendment increased penalties for those immigrants who commit crimes after unlawfully reentering the country, or who are convicted of reentering the country multiple times. Immigration offenses comprise a large portion of the federal docket, and these enhancements may affect a large number of cases. They also simplify the application of the immigration guidelines. Over the last 6 years, I've traveled throughout the nation, from coast to coast, on the border. I've traveled throughout our great country, and I've spoken to different audiences about the challenges confronting the federal criminal justice system today. Whether I'm addressing a room full of federal judges or a group of law students, I've always emphasized that the Commission's decisions are evidence-based and data-driven. During my tenure, the Commission's Office of Research and Data has analyzed 397,248 individual cases, cataloging the pertinent sentencing data into a comprehensive computer database maintained by the Commission. Our detailed synthesis of sentencing data has culminated in 60 publications, ranging from significant research reports, those big, thick things that I know you all love reading, to those 23 two-page quick facts that Glenn Schmidt has been, and his crew have been so creative in creating. These two-page documents focusing on a variety of issues in the criminal justice system. We have also responded to 845 special data requests. Since 2012, the Commission has made its prison and sentencing impact analyses available to the public on its website, and this year the Commission launched a redesigned website to make it more accessible. The Commission's reports have a continuing impact on educating policymakers and the public. For instance, several of the Commission's recommendations in its 2011 mandatory minimum report are reflected in bipartisan legislation now pending before the House and the Senate. We uniformly concluded that mandatory minimum sentences in their current form are often too high and applied too broadly to lower-level defendants, and the most severe penalties are often applied inconsistently. So that's why we've urged Congress to reduce the current statutory mandatory minimum penalties for drug trafficking, to consider expanding the safety valve to allow a greater number of nonviolent, low-level drug offenders to be sentenced below mandatory minimum penalties, to give retroactive effect to statutory changes made by the Fair Sentencing Act of 2010, and to reassess the scope and severity of the recidivism provisions in the statutes, which can double the mandatory minimum penalties if a drug offender has a prior conviction for a drug trafficking offense. We plan to update that pivotal mandatory minimum report with more current data in the future. And it's my hope, and I think all of our hope, that the Congress, the executive branch, and the public continue to base sentencing laws and policies on the Commission's high-quality data and thoughtful analysis. So much bipartisan progress has been made in criminal justice reform. I am so hopeful that the 115th Congress will pass meaningful legislation. So, at this point, I'd like to turn this over to my fellow and sister commissioners and to see if they'd like to add anything.
Well, I'm not shy, so I will. This is our last meeting, but more significantly, it is the conclusion of Judge Sarris's leadership on this commission, and it has been universally acclaimed as extraordinary. It's extraordinary because she has brought to this commission a sense not only of collegiality, but of truly listening to varying points of view in an effort to try to resolve differences. She has been guided by the principle that the perfect is always or frequently the enemy of the good. And so the idea is to try to achieve some basic fairness, some result that will alleviate situations in which injustices occur. You note that it's an interesting thing for a judge to be part of to be part of an administrative process where what you have to do is try to achieve some sort of compromise in order to achieve a result that is progressive. And it is a commission that's not nonpartisan, it's bipartisan. And it's bipartisan because of the effort when the commission was established to try to get different points of view expressed on that commission. And it has been my pleasure, and I think every commissioner's pleasure, to be guided in that task, which is a difficult task, because it's a task that always involves some sort of compromise, to be guided by Judge Saris. Her leadership has been extraordinary. The Commission has received a number of letters. Let me just cite to two. One comes from the Justice Roundtable, which is a collection of groups that are very interested in establishing communication with the Commission in an effort to try to achieve progress and reform in sentencing, and they acknowledge Judge Saris's leadership. That letter will be part of the placed on the web. And also, if I might, I'd like to mention a letter that Congressman Conyers wrote a few days ago. And I'd like to read excerpts of that. Dear Judge Saris, as your term comes to a close, I would like to thank you for your leadership of the United States Sentencing Commission and your commitment to achieving sentencing reform and equal justice for all. You were appointed to chair the Sentencing Commission during a critical period in the evolution of our criminal justice system, marked by an increased openness to rethinking sentencing policy. At that time, President Obama spoke of your unwavering commitment to justice and his confidence that you would serve with excellence and integrity. He was correct. Your work on the Commission clearly showed your dedication to justice over the past years. As chair, you led the Commission with fortitude, dignity, working to address important issues such as sentencing disparities, the unwarranted and costly growth of the federal prison population, and the unintended consequences of mandatory minimum penalties, especially among minorities. Your extensive legal experience and knowledge, combined with an obvious passion for justice, equipped you to guide the Commission through a time of robust reflection and innovation to accomplish many substantial milestones. Your efforts made certain that the purposes and the goals of the Commission were fulfilled. He cites the particular achievements of Judge Saris and concludes, you serve with diligence, distinction, and honor, always with a sense of urgency in formulating solutions to issues identified by the Commission, seeking to promote fairness and public safety. I applaud your efforts to foster public trust and respect for our criminal justice system. Although you are leaving the Commission, I know you will continue to work to improve our criminal justice system. Thank you for your leadership, advocacy, and service. Signed, John Conyers, Jr., Member of Congress. And that sentiment, those sentiments have been echoed by so many people and captured by Ken Cohn yesterday in his tribute to Judge Saris. As we know, the Commission at the end of the session may very well be reduced to 2 members not having a quorum to act. And so the question is, well, what happens? What happens to the Commission? And I want to suggest as one person that while the Commission, in terms of promulgating amendments and taking official action, may have some brief period of hibernation, the Commission itself does not. That is the staff itself, the Sentencing Commission. The work that these people in the room do is extraordinarily important. It is the gathering of data from which evidence, and that's the evidence, drives decisions of judges After all, the sentencing guideline system is primarily directed to judges, so judges can make decisions as to what are appropriate sentences. So, Glenn, you have to redouble your efforts, which are extraordinary anyway, and gather all of that evidence, because it is the evidence that drives it. A second task that I would just like to acknowledge, and I can speak to this, I think, because I am a judge, is the importance of the training that the Sentencing Commission does. The fact of the matter is that by going out and talking to judges and explaining to judges how the guidelines operate and how they operate in a way to try to ameliorate the disparities that may occur throughout the country is extraordinarily important. And in my travels, and I think in the commissioner's travels, we have constantly been applauded. We take, of course, the credit, but the credit really goes to the staff of the commission for engaging in this important task. And Raquel Wilson and her very devoted and very talented individuals who work with her must continue this task of educating judges as to the relevance of the guidelines. Finally, sort of a personal note, I've now been associated with sentencing issues since 1967. I did the math. I'm not as good as Dabney, but alarmingly, it looks like it's like 50 years. So I've been involved in this 50 years as a prosecutor, as a defense lawyer, as a judge. Not yet as a defendant, but those 50 years, you would think after 50 years, I would know what a right sentence is, the correct sentence in any given situation. And I'm not confident that I do. And nor do I think any judge is confident that he or she has articulated the correct sentence in any given case, because it's not susceptible of that type of analysis. More importantly, you do know, or you should know, what a wrong sentence is, what a sentence that is inappropriate to the circumstances. And the guidelines help fashion a judge, anchor a judge in terms of applying a better sentence to any given situation. So it serves a tremendous role. Now, if I may say about my fellow commissioners, when we joined this commission, we all articulated the thought that we cannot allow the perfect to be the enemy of the good. It's important in this type of situation to try to arrive at compromised positions, at positions that further the purposes of the sentencing guidelines. It has been, I would say, really a remarkable experience for me to work with Judge Pryor, who is one of the most principled individuals that I've ever had the opportunity of working with. While we may not share, I think it's fair to say, exactly the same ideology on all of these issues, nor does any judge necessarily share the same ideology. And the purpose of the guidelines and the purpose of this commission is to try to articulate these views and to see whether or not there is common ground. He has been a leader of this commission in arriving in a collegial way at common ground in our deliberations, and it has been my honor to work with you. Dabney, of course, brings not only the institutional memory of the commission, but also a willingness and indeed a zeal for looking at what the evidence is with respect to any particular suggestion that's been made. And it's interesting. It's interesting, you all don't see it, but it's interesting that when you start talking about the evidence, what does the data show? It informs the judgment of commissioners as to what the proper path is with respect to any given amendment. And of course, it's been a delight, Rachel, to work with you, because while you're an academic, You are a practical academic, and that is to say, you have your feet and your soul rooted in reality and in a sense of improving the system. And I think the commission is extraordinarily fortunate that you will go forward as a commissioner. It has been a honor, privilege for me to do it, and I would say that Patty, just none of this would have happened. None of this would have happened without your leadership, and so I'm indebted, but really the country should be indebted by the service. The fact is that without that type of leadership, I don't know what we would have accomplished. So thank you very much.
Thank you.
What a tough act to follow, always.
I'm glad he went after me.
I know. Oh, well, I will try. But thank you, Judge Breyer, and thank you, Judge Saris, for your very, very kind comments. It has been, for me, such an incredible honor and privilege to serve these last 10 years. I am very, very sad to go. And I'd like to start by thanking both Presidents Bush and Obama for giving me this opportunity, truly an opportunity that has been one of the highlights of my professional career. And that's not just because of the important work this commission does, but it's the people with whom we serve. And let me start by talking about the staff, which is both Judge Saris and Judge Breyer have made clear is just extraordinary. You all bring such expertise and professional judgment, good judgment, wisdom, and dedication to your jobs that we, the commission, simply could not do what we do without your help. And I am deeply grateful for all the long hours you put in, and treasure your friendship, and I will miss you dearly. I'd also like to thank the stakeholders. All of you do so much to enhance our decision making and inform our judgment. I know many of you have other jobs that you do in addition to this, and yet you write very extensive, thorough, and solid both written comment. I know it takes great time to prepare for your testimony before us for hearings, and also the informal feedback you give us, and we really appreciate it. We learn from it and benefit from it enormously. In these next few months, as Judge Pryor and Judge Saris noted, we're going to be in a period of transition here at the Commission. But I have no doubt with this staff, this expert staff, and the commitment of our remaining commissioners here, that the good work will continue. And I just like to talk about two areas in particular that are of most interest to me. The first is the Commission's ongoing work on recidivism. This research is critically important, not just to this Commission, but to all policymakers who are looking at the criminal justice system. And it really, the data is the gathering is impeccable. It's data no one else has, and it really helps not only us, but all of the outside world, and particularly the policymakers. So I know that it will continue to shape criminal justice reform in this interim, and as we continue to face big challenges with the overpopulation of the Bureau of Prisons, I know the Commission's work in this area will be instrumental. Not just ensuring that lengthy prison terms are reserved for those who pose the greatest risk to society, but also to help both BOP and others provide the kind of support and programming that will help prisoners successfully integrate into society without jeopardizing public safety. And we have to do a better job of programming. I've spent the last couple years doing a lot of volunteer work in a federal prison, and we can do better. We must do better. Most of the inmates face significant challenges in terms of not just addiction issues, but also learning disabilities and mental health issues. And we can do better. We must do better. Not only is it the right thing to do, it is the cost-effective thing to do. A recent RAND study concluded that for every dollar spent on evidence-based educational programming, there's a $5 decrease in recidivism costs. So programming good, effective, evidence-based programming makes a difference, and I hope the Commission's continued research will shed light on this subject. Another important priority of the Commission is its continued focus, I hope, on structural reform of the guidelines. As currently structured, the guidelines cannot fulfill the goals of the Sentencing Reform Act, and we simply cannot ignore the increasing disparities in the system, especially the demographic disparities. And I hope that the future Commission will work with Congress to both restructure and simplify the guidelines to better meet the goals of the Sentencing Reform Act. And finally, the commissioners. This is, as I said yesterday, one of the most professional and collegial bodies that I've ever worked in. And Judge Saris, as I said yesterday, I credit you for the leadership. You have really set the tone, not just within the commission in terms of how we treat one another, and the staff treats one another, and we interact with staff, but also in terms of the outside community. And you have done a great deal to make this place the place it is today, and you've just done an outstanding job. So I thank you for your service. It has been such a pleasure to serve with you and with all of you. Each one of you really epitomizes the role of a public servant in every way, what that should be. And I'm deeply grateful for your friendship, and I will very much miss working with all of you.
I'd like to say a few words too. I think that the last several years will be remembered as one of the golden eras of the United States Sentencing Commission. We have tackled some of the most difficult problems in federal sentencing, and the Commission has resolved those problems with what I think are thoughtful and data-driven solutions. I want to highlight three. We've satisfied our statutory mandate to address prison overcrowding by reforming the guideline for drug trafficking and by making that reform retroactive. We have reformed the career offender guideline to resolve some of the most vexing and difficult problems in federal sentencing. And we have reformed the immigration guideline and simplified it in a way that will save considerable tax dollars and result in fairer sentencing. None of these reforms could have been achieved without the contributions of the commissioners whose terms will soon expire. Judge Patty Saris has been an exemplary leader for this commission. She has been thoughtful, hardworking. I will say about hardworking. We will get in commission meetings and beg her for breaks. She has fortitude. She is serious, always cheerful, fair-minded, and above all collegial. We could not have asked for a better leader these last few years. The same is true for our vice chair, Judge Chuck Breyer. The wisdom and wit that he has brought to our work has been extraordinary. And I could say a lot more, but I want to say most of all, I certainly hope that he will soon be given the opportunity to serve again on the commission. We need him. And I want to thank Commissioner Dabney Friedrich for her long and distinguished service on the commission. She has brought a unique mix of experience as a Senate staffer, federal prosecutor, and associate White House counsel to assist us in our work. And I want to echo two things that were highlighted earlier by Judges Saris and Breyer. As Judge Saris rightly pointed out, Commissioner Friedrich has often been the necessary commissioner to provide us the key idea to resolve some kind of problem as we have considered amendments to the guidelines. And I don't know how we could have resolved these problems in the last few years without those insights. And as Judge Breyer pointed out, her institutional knowledge too has been invaluable, particularly in reminding us as we think about and deliberate about various issues that previous commissions have thought about and tried to tackle those same issues, and she's helped us avoid going down trails that would have been unproductive. I'm proud to call all of these commissioners my friends and colleagues. I want to congratulate them and thank them for their terrific service to the federal judiciary and most of all to the American people.
So I would like to say a few words too. I think it can be easy to become cynical about bureaucrats in Washington or what the government can accomplish. But as a member of this commission for the past 3.5 years, I've had a front row seat to government service at its finest. And it's highlighted for me all that can be accomplished with the right people. 3 of the finest colleagues I have ever had are leaving the commission today. Thankfully, one is staying. And I want to take a moment to reflect on what an honor it's been for me to serve alongside them. Judge Saris, Commissioner Friedrich, and Judge Breyer, they represent the best of government service. They've approached every decision we've made at the commission in my time here with careful attention to our authorizing statutes, the empirical facts, and what would further the public interest. And we come from different backgrounds, and we bring different perspectives to the issues. And yet this group, usually reaches consensus about what we should do because that is what we're guided by. We're guided by data, a commitment to the rule of law, and well-reasoned arguments. And so our discussions of issues are always respectful and productive. And actually, they're usually pretty funny, too. And I couldn't have dreamed of a better group of colleagues. I want to give special thanks and appreciation to Judge Saris, our chair. So my other hat, as has been mentioned, is also as an administrative law professor. And what I usually teach is dysfunctional agencies that fail, all the ways in which they go wrong. And I will just say that I wish that Judge Saris could run every agency in our government. If we could just clone her, we would solve so many problems because the culture that she has fostered here at the commission is the ideal culture for good decision making. Everyone comes prepared, and she sets that example right at the top. Everyone feels comfortable speaking his or her mind and representing whatever view they have because you know that's going to be aired and respected, and we'll all talk about it. And she keeps us moving along. She runs an efficient meeting, and then she guides us to common ground. So it's not surprising to me that the commission has accomplished what it has under Chair Saris, and it really has been one of the honors of my life to be part of this. I'm very proud of what we've accomplished, but the credit is really yours for your guidance. So I always look forward to these meetings. I get on the train, and I'm excited to come down. I can't wait to talk about it. But that wasn't true this time. I was really sad. I'm really sad to see you go. Now, thankfully, we're going to still have the best staff. That's the other thing that makes our agency really great is the staff is incredible. They are so dedicated and hardworking and smart and wonderful to be with. And that same is true of Judge Pryor. So I'm not alone, and I'm very happy about that. And I really hope that Judge Breyer will be coming back, as I echo the fact we need your service and you're tremendous. But I know I speak for everyone here when I say we will miss you all tremendously. You will leave a void that I think is impossible to fill, but a legacy that I think will continue to guide us. I fully expect to be hearing your voices in my head in a hopefully sane way as we on future issues. So thank you. Thank you.
All right, so on my personal behalf, but also on behalf of Commissioner Jonathan Wroblewski, who preceded me, and of course on behalf of the department as a whole, I also want to thank the departing commissioners for their collaboration with us. I'll start with Commissioner Friedrich. Your exemplary career path from your work as an AUSA in San Diego and in Alexandria to the Senate Judiciary Committee, to the White House Counsel Office, and of course your time at the Commission shows a true commitment to furthering the causes of justice. But what is most important is your work with the inmates at the Federal Correctional Institution at Dublin. As was previously noted, you have shown an unwavering devotion to the women and bettering their lives through education. Commissioner Friedrich has advocated tirelessly in the prison, and to the director of BOP and to department leadership. We think it's fair to say that the department's new initiative to reform federal prison education programs is due in large part to your efforts. So, Commissioner, we thank you for all your tireless work on this, and we hope that our collaboration continues. And of course, Chair Saris, as so many already have noted, you have shown extraordinary leadership during your tenure here at the Commission. And together, we've addressed many important issues, from healthcare fraud to the theft of trade secrets, from firearms violence to implementation of the Fair Sentencing Act, drug sentencing policy, retroactive application, and simplification. You've guided the Commission deftly and ensured that the voices of defendants, law enforcement, crime victims, and the public at large have been heard. We appreciate all that you've done and for being such a strong partner over the last years. And for those of you who don't work with her behind the scenes, Judge Saris is just as pleasant and approachable, no nonsense as fair as she appears in public. And when confronted with policy questions, as Avila has noted, she's always considered the question head-on, open mind, and considered science in consulting her real-world experience in assessing the right outcome. And what's more, she shares all that experience with us, and it's amazing how she always seems to have a defendant that was just before her that had the same issue that we're discussing. So she'll walk us through the analysis and lay out her conclusion, and does it in a way that it invites conversation, challenge, and it becomes a true give and take, that which, as others have noted, is what makes policy work. And also, she always finds a great pun to tie all these things together and make us all laugh. But all in all, Chair Saris, you're leaving this institution, as others have noted, stronger than you found it. And your leadership has contributed to greater justice in ways large and small. And for that, the Department of Justice will always be grateful. And Judge Breyer, like others have noted, we are hoping you get extended, so you don't get you don't get special notes. We really hope to see you, as well as Commissioner Pryor and Commissioner Barkow, in 2017.
Thank you.
Thank you. Wow. It's a very sad day for me. As you can see, all of us have become very close friends as commissioners. It's such a thank the president for nominating not just me, but everybody here, and also the Congress for confirming us. It's been a true honor. I'm pleased with the accomplishments of the last 6 years, and grateful to everybody in this room for helping. I wanted to mention that what I'm hoping to convey is, regardless of how many commissioners there are, our work goes on. We're working hard. We're working hard on reports. We're working hard on amendments, and it's important that you all stay with us as the years go forward. To that end, I'd like to acknowledge that there will be a new acting chair announced as my term ends with the conclusion of the session of Congress. I am confident that the future commission and the commission staff will remain dedicated and serious about the important mission. And as we all look back on 30 years of guidelines and work of the commission, I appreciate it. Really my honor to serve as a chair during this historic period. It really was historic. I remember being asked to be chair of a commission. I'd never been chair of led an agency before, and each opportunity, each new challenge, I was helped by everyone here. So while my time is ending, the work goes on, and I urge each one of you to remain focused and dedicated as ever to the guidelines, which are fair, effective, and just, and to make sure they stay that way. Thank you very much. Should we call this? Do we have a motion to close?
I move that we adjourn.
Please, no one second.
No one's going to.
No second, sorry. Not going anywhere. Is there a second? Now what do I do?
I'll second.
We'll walk out arm in arm,
Yeah.
Dan. That's how we walked
Yeah.
in. And the meeting's now adjourned. Thank you very much.